Attorney Pence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 with Canada Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is a second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Craypence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Craypence? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years, 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay estate, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? friends?
No, Your Honor, my client has signed an affidavit of agency from their code.
Thank you, yes. I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. And in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person that could have stopped the whole thing with 1 phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 cases. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk out the side door. Moving on. Thank you, Mr. Craig. It's my pleasure to meet you.
Thank you, my pleasure.
Have a good day.